So, the court has entered an order that reflects the court's ruling when the parties were before the court last week. There are two issues before the court this morning, at least as the court understands. One is Mr. Worthington's motion to supplement the record and to remand. The remaining issue is Department of Agriculture's motion for another scheduling order so as to facilitate what agriculture advises might be dispositive motions. So let's take the first issue, which is Mr. Worthington's motion to supplement the record and remand. Mr. Worthington, what emails in particular are you requesting, or documents are you requesting?
There are emails from a public. Your Honor, can I, before I start, can I make a point of order type of observation?
Yes.
At the last hearing, Mr. Calkins argued that the working group documents were already on the record. And what I have on the table back there is in that little box is the agency record. So I checked the agency record, and this document is not in the agency record. So I don't know if he's aware of that. My suspicion is that he is aware of it because he's made specific arguments that the working group is internal and not external. So although you have allowed this document to be placed on the record in the order, he has made a claim to you in his testimony that this document is in the agency record, and I submit to you that it is not.
Mr. Calkins?
Your Honor, this is in the agency record. We've cited in the prior pleadings the page of the agency record where it is found. So it's, I don't understand where
I'll be reviewing the record. If it's in there, it's in there. If it isn't, I'll let the parties know.
I mean, I can cite where it is if you want me to take.
Why don't you tell me where, if you have that citation?
There's a,
It's the sign-in sheet, as I recall.
that's right, Your Honor.
They removed the working group from the SBIS. So when I look at what they gave me, and I think that's the box you should be going through, they removed the whole working group from the SBIS. So not only is there a sign-in sheet, but there's a reference to it in the SBIS in section 7. That's all gone in my copy. It's not there.
I don't know what's in your copy or what isn't. I'm going to look at the record in the case.
Your
Mr.
Honor,
Calkins.
You'll see the references to the working group have been completely removed from section 7. It's gone.
Your Honor, again, Mr. Worthington is misguided. He's misinterpreting what's in the agency record. The agency record contains records for two chapters of the rules that were being amended. One, the SBIS is combined for the seed certification rules. Those are chapters 16302 and 16303. Neither the SBEIS for that rule set does not contain the paragraph that Mr. Worthington is arguing was inaccurately removed. However, the rules that he's challenging, the primary set of rules, are the rules that develop the program itself and the licensing. And that SBIS contains the paragraph that he's claiming was illegally removed, and it's in the agency record.
Okay. Do you have a citation for that?
I can hand forward.
If you just tell me,
It's
is it page stamp?
the agency record for the small business economic impact statement for the licensing rules begins at agency record 383. And on page 391 is where section 7 is located, and that's where the paragraph exists that Mr. Worthington is arguing was, illegally.
I can see it, Your Honor. I can see it.
Okay.
But Your Honor, my concern is this. First of all, this only came up in the reply. And this is just a point of procedure, Your Honor. Mr. Worthington has been consistently not serving me at the address where my office is located on my notice of appearance.
Yeah, you have the right.
I emailed him on December 18th. I said, you have to serve me at my office address. He has not done so. He's serving pleadings to the Tacoma office. He's serving pleadings to the Highway Licenses Building. That isn't my address. We have offices throughout the state. Secondly, his reply, which is where all of this comes up, was late. Okay? He served it to the Highway Licensing Building, which is on the Capitol campus, afternoon on Wednesday. Had to be filed before me, but wasn't served where I work. There's 200 attorneys in my office building in Tumwater by the airport. That's the address on my notice of appearance. He is disregarding his requirement to serve me where my office is.
The court's inclination is to continue this hearing so that Department of Agriculture has adequate opportunity to reply to, or at least adequate opportunity to review the documents that were late filed and arguably not provided to the Department of Agriculture to the right address.
Your Honor, may I respond?
Yes.
I am prepared to argue the merits.
Okay.
My concern is going forward. This is a pattern by Mr. Worthington. I've asked him to serve me where he's supposed to serve me. Today he's disagreed with it. That is an obligation he has.
Mr. Worthington, what's your position with respect to serving Mr. Calkins?
We have fought 2 previous cases in front of Judge Murphy. One was a public records request suit. One was an antitrust case. I served Mr. Calkins at the locations that I continue to serve. What we are approaching now would be what the Court of Appeals and even the Supreme Court would be considered to be an invited error. To raise it now on the reply on the 18th, which is after he's actually replied to it, it's invited error. I would have been glad to, and in his email, if he would have put his address on there to remind me, I would have been glad to have him served at his office.
Mr. Calkins, which address are you requesting that Mr. Worthington?
Your Honor, it's the same address on the footer on my email to Mr. Worthington. It's the same address that's on all of the pleadings on the footer.
Let's put it on the record.
Okay. It's the address on my notice of appearance. Just grab a pleading.
I know the address.
Okay. 2101 4th Avenue, Suite 700.
Clearwater Lane.
Clean water.
Oh, I'm sorry. I apologize. I'm looking at
I believe
the
it's
wrong
Clearwater.
Here it is, Your Honor. Sorry. It's 7141 Clean Water, one word, Drive, Southwest, P.O. Box 40109, Olympia, Washington 98504-0109. And, Your Honor, in the prior litigation that Mr. Worthington's referring to, we had an email service agreement except for original service of processing. So that's how pleadings were served in those cases. We don't have that in this matter.
Then the court will order that any pleadings filed by Mr. Worthington be served upon Mr. Calkins at the address that Mr. Calkins has placed on the record. Okay. Now, turning to the matter at hand, which is Mr. Worthington's motion to supplement the record. Mr. Worthington, tell the court, please, which documents or emails you are asking to be included in the record.
There are additional working group comments that are all from the same public records response from the agency, number 1459, which the court has already allowed to be supplemented on the record. And then there's documents from Washington State University themselves And I sent them exactly what I sent the court. I made a PDF, I sent it to them, and I got them to authenticate that that PDF came from their public records response to my request for documents in the working group regarding the working group and Washington State University's role in the working group.
Okay, I understand that, thanks. I guess what, to be more specific, what the court is asking is, can you refer to documents perhaps in your motion or your declaration that you are asking the court to include as part of the record?
They were, I'll have to get the motion and read it.
Yeah, can you please? So on December 18, 2017, Mr. Worthington filed a motion to supplement the agency record, the second amendment, and a declaration in support of that second amended motion.
Skipping over the, what I would consider to be the authentication sections, which is the first 2 pages of the declaration, showing where I got the documents. It would be, these are emails October 28th, or October 20th, 2016, from Laura Sue Levine to Emily Febles,
Okay.
saying it was
I
great.
got that. I'm with you. Go ahead.
Okay, and then the next one would be on October 20th from Victor Shaw to
A number of different people.
variety of people.
Okay.
We are reaching out. April 25th, Dan Perfect, I will add the letter, and thanks, Dan Northcliffe, which I believe is the next page.
Okay.
And April 25th response. And then there's another short page. Please let me know if you have any questions. And then the May 17th, 2017, I looked over the applications. Some changes may be appropriate. And then, hi Emily, this was May 17 again. I sent you a draft, the application. Hopefully you're willing to look it over. And the May 19th email from Laura Levine to Emily Febles. Great, thank you, it's helpful. August 18, 2016 email from Emily Febles to Steve Fuller. And CC, if there's anything I may do to assist, I look forward to working with Wazoo to create a sustainable. May 3rd, definitely would be happy to help, from Emily Febles to Daniel Nordquist. November 28th, from Albert Suey with a T. Laura and I looked at this and it looks good from our perspective. Any word from the AG's office? Follow-up page. I would love your input. And then I took a snapshot of, this is for more authentication from the court. And in the upper left-hand corner, you'll see the public records request number 17-295. This is a duplicate email, but it's a screenshot showing you where it came from to provide additional authentication other than what I've already placed at the front of the declaration.
So you're not asking the court that that document be included in the record, is that?
It is repetitive, but
Okay.
in case the court has concerns on authenticity, then I would submit it.
Understood.
And then November 28th, I'm working on developing a structure for the university license. Would love your input. That's from Febles to Albert and Yang. And then this document is in both the next the document that is a chart. This document actually exists in both the Washington State University email response and 1459. So you can take your pick on where the authenticity comes from, but this is something that Agriculture sent to the Department of Washington State University asking their input on.
How do we know that?
Well, it's tough because Wazoo didn't put any bait stamp numbers, and I asked them to, and they said it would be too difficult for them to go back and bait stamp. A lot of folks, when they do a public records response, they'll put a number at the bottom which tells us where it came from. Right now, you're counting on my declaration that this document is what it says it is, and I made a prima facie
Understood.
under ER 104 or 901 that says this is what they sent to Washington State University for their input. And it was actually attached to the previous email. And April 24th, 2017, here are copies of the draft applications for the industrial hemp license. That's just April 24th. I look forward to your feedback. Let me know if you have any questions. This is from Emily to Laura Levine. This is Washington State University. And again, this is a copy of the attachment that they sent to Laura Levine, the application for them to look over and give. So the next few pages are the actual application that they sent in the attachment. Again, although at the bottom one of them says ag form, this does not have a base stamp number. This is why I put all this in a PDF and sent it to them to try to get them to authenticate it, rather than have them place base stamps. They do have 1,000 more pages of working group documents that they couldn't get to me. And so I'm asking that all these be put on the record. I'm not asking the court to waive on the 1,000 because I do believe I'm ready to proceed.
And then the next document or email
And then the next one,
is dated
after you get through the application,
December
it is an
16th.
email on 12/5 from Emily Febles. This would have been part of Exhibit 2, which was in the Agriculture 1459 that I tried to get you to put on the record last time, but you correctly stated that I had to put it in the motion to give the state a chance to respond to it.
Okay, give me a moment here. I'm not seeing that email. You said
That's under Exhibit 2.
Okay.
And that's it.
Okay.
Right after these are on, if you allow them onto the record. Now, Mr. Calkins has continuously argued that these are irrelevant to the rulemaking file issue, but again, he does not address the pre-notice inquiry issue and the other issues that are in the amended petition for judicial review. He puts all his eggs in the rulemaking file basket, and he didn't argue whether or not these documents would be relative to the pre-notice inquiry issue. And I argue that it is, because you can see that the agencies are exchanging documents and asking for comment on the layout of the documents as they make their rule. And I believe this falls under, and it's perfect, this is what I explained to you before. This is allowable under the rulemaking process if they notify the public that they're going to negotiate the applications and how they look. If they're going to negotiate rules with a particular agency, then they should notify the public in the pre-notice inquiry. Mr. Calkins hasn't made any argument on the entirety of the amended petition for judicial review. He strictly wants the court to focus on the rulemaking file and whether or not these internal documents were required to be in there to begin with, but he does not offer any explanation or argument and case law argument to the court on how they aren't relevant to the pre-notice inquiry allegations, the violations of the pre-notice inquiry allegations. And based upon that, I argue that the documents should be allowed on the record because they are relative to, I'm still going to argue they're relative to the rulemaking file issue, but I'm saying that he hasn't, I'm also saying that they're relevant to the pre-notice inquiry requirement and argument. I'm not asking you to decide the merits of those documents, how they're applied. At this juncture, I believe I just have to show you that they're relevant to the pre-notice inquiry allegations in the pre-notice inquiry. And again, Mr. Calkins doesn't have any argument to that effect.
Mr. Calkins?
Your Honor, thank you, Your Honor. Mr. Worthington has the burden of demonstrating why under particular statute 3405, 562, sub 1, why these records should be admitted. And in our response, we pointed out that he's made only conclusory arguments. He cited the statute, but he just said it's his belief that they fit and therefore they should be admitted. So there's no legal authority. His reply brief, he can't begin to bootstrap in argument in a reply brief that I don't have any opportunity to respond to under the court's own rules. So his arguments today, he doesn't raise the issue of how these things tie into his amended petition or anything else in his motion. So he hasn't met his burden. If the court, and again, if the court wishes to allow him to admit these documents, we've, in our response, suggested that the court use for Exhibit 2, that particular email, the full email string. This is just internal emails between people at WSDA. It's not external. His one pager is out of context, and his comments about hashing out details are completely misinterpreting what is stated in the actual email. It's talking about internal communications, not hashing out details with external stakeholders. So if the court is persuaded somehow that this set of emails should be allowed, Exhibit 1 are the WSU emails, including to and from my client. Exhibit 2 is internal email. We would suggest that the internal email, Exhibit 2 in his motion, be admitted only through the full string, which is attached to as Exhibit A to my response.
That's going to be the order of the court.
Thank you, Your Honor.
We'll grant the motion, but Exhibit 2 will be the full string of emails.
Your Honor, just the full string meaning what was discussed during argument.
Yes.
Okay.
Department's motion for amended scheduling order. Mr. Calkins.
Thank you, Your Honor. Your Honor, our motion is based essentially on the pleadings. If the court has had an opportunity to look at Mr. Worthington's amended petition and his burden to meet the obligations for the remedies he's seeking under that, there are three different types of dispositive motions that are on the face evident. One is that he's failed to join indispensable parties. There's an exhibit that has been attached to a declaration of the WSDA's public records officer, which attaches the list of current licensees. There are 7, that's exhibit either B or 2 to the declaration of Pam Poplin filed prior to for the hearing on December 15th. That document shows 7 current licensees that have a vested interest in growing or processing industrial hemp under the current program. Mr. Worthington's amended petition at section 7.4, part of the relief he's seeking is to have those parties, they're not named, but they're identified by class, their ability to participate in the program terminated. So that's a classic CR 19 situation. We're not arguing the merits of that they are indispensable parties. We're just simply saying we should have the opportunity to be able to file a dispositive motion prior to the court having a hearing on the merits of the amended petition. The other issue is the issue of standing. Mr. Worthington's response disregards, maybe overlooked, the statute in the APA RCW 3405-530, and that's the criteria to have standing that have to be met. And we would request an opportunity to present a dispositive motion to show that Mr. Worthington doesn't have standing. We're not arguing the merits of why he doesn't have standing. We're just saying we request the opportunity to do that. Additionally, under the particular section of the APA, the rule challenge section, which is 3405-570 sub 2, there's particular subsections that are referenced in our motion and in his amended petition. Mr. Worthington has to show substantial prejudice, etc., if regarding the alleged irregularities in rulemaking, and that's a dispositive issue that we would like to be able to bring. What I would propose, Your Honor, is that there are different ways to do this, but we've argued that we would be prejudiced if the court doesn't have subject matter jurisdiction to hear this matter, which the court could grant at any time. In fact, this court could do that sua sponte. But we know that Thurston County Superior Court has very particular requirements for dispositive motions. Those conflict with our ability to have a dispositive motion noted prior to the briefing schedule in the current case schedule, which starts January 2nd, and runs to February 16th when there's the hearing date. What we would suggest is that we use the local rule, the CR 56 28-day schedule for dispositive motions, and I've looked at a potential calendar, and potentially we could have that briefing schedule set for the dispositive motions to be heard on February 16th in lieu of the current hearing on the merits of this case, and then depending on the court's ruling, issue a new case schedule order for hearing on the merits.
Thanks. Mr. Worthington?
Your Honor, I have requested relief under a specific rulemaking challenge statute. And I serve the agency, I name the agency. The court has acquired appellate jurisdiction. I am concerned about how the last hearing ended, and I don't want you to take this the wrong way, because it looks to me like what he's arguing is that he wants you to set aside appellate jurisdiction and then do this number under a superior court jurisdiction outside the appellate rules, which I've invoked. So at the point where you decide that you're going to put aside the appellate jurisdiction and where this superior court jurisdiction at under the civil rules, which he didn't respond to. He didn't, and in response to his earlier allegation, I'm the one quoting case law. I'm saying this argument, and I'm supporting everything by case law. I'm very conscious of that because I've had a lot of cases dismissed because I didn't. So here's what he's asking you to do. He's asking you, without any evidence at all, who these other parties are, based on what might be impurifications in the amended petition, which you have to look at the causes of action and what relief I'm requesting. And I'm not requesting relief under these areas that he's asking for you to forage into. You have appellate jurisdiction to decide the rules. I named the agency. He's trying to get to standing in a CR 59, which allows you to dismiss the entire case and not decide the merits and send me on this run around the judicial mulberry bush, where I go up and appeal a superior court jurisdiction when I brought you an appellate court jurisdiction. And it's wrong. I'm ready to proceed. I can make my arguments based upon what the record is now. We're wasting time. He hasn't provided you any people at all who their names, he's hinted, but do they relate to the causes of action? No, they don't. Do they relate to a rules review challenge? Do they relate to a rulemaker's role in a rulemaking challenge? No, they don't. He didn't respond to any of this. He got in trouble with Judge Murphy for doing this kind of thing before, where he basically puts it at the court's feet and doesn't really respond. Maybe it's because I'm pro se. I don't know, but I know my way around these laws enough to know what he's trying to get you to do. He's trying to invoke a civil rule in an appellate jurisdiction in a review of an agency's rulemaking process. And I'm thinking that the minute you do that, then I have grounds for an interlocutory appeal because you've abandoned the appellate review. And here's the other thing, and this is the part that's more disturbing to me. We set this schedule in November. Now at that time, the agency record was what it was, and they were more than comfortable to deal with this briefing schedule then. It wasn't until I started adding stuff on the record, and the briefing schedule starts next week, so now you have this 24th hour request to halt the briefing schedule. So basically, they want to make a standing argument because I haven't seen any other indispensable rulemakers. I haven't seen any indispensable parties. And in the case in front of Judge Murphy, he argued that all that had to be done under the APA anyway. So you have everything by allowing him to make this 24th hour argument. You're allowing him to strip you of appellate jurisdiction, which I have rightfully required. He can argue all his standing issues in your appellate status. All he's doing is just getting a delay from you. And he's not going to provide you with indispensable rulemakers, because there aren't any. I gave you the statute, I gave you the session law and the statute. There's only one rulemaker, and that's the Washington State Department of Agriculture. I'm challenging their rules.
I'm ready to roll. This is, with zero disrespect to Mr. Worthington, this is a very simple issue for the court. These types of cases that come to Superior Court in an appellate capacity are, by operation of court rule, assigned an expedited hearing schedule. And from time to time, this expedited hearing schedule is such that it does not allow parties opportunities to avail themselves of, let me rephrase that, because of expedited hearing schedules or trial scheduling orders, the parties do not always have an opportunity to come to court to argue dispositive motions. This court, sitting in the role of, to use Mr. Worthington's term, an appellate court, which the court does not take exception with, still may, and frankly quite often does, consider dispositive motions sitting in an appellate capacity. Both parties should have an opportunity to do that, and they don't have under the current case scheduling order. When we were last in court, Mr. Calkins, without making a motion, just advised the court that his client had some concern with respect to an ability to argue dispositive motions under the current case scheduling order. And the court, without making a ruling, just simply placed on the record that the court would be amenable to a motion to enter a new scheduling order so as to allow either or both parties an opportunity to file and argue dispositive motions. Dispositive motions occur in virtually every sort of civil case, including cases in which Superior Court sits in an appellate capacity. So I understand Mr. Worthington's argument. All of that being said, this is a very simple issue for the court. The court grants the motion of agriculture. The court will enter an order requiring a new case scheduling order and require the parties to comply with local court rule 40. We're not going to keep that February court date that was mentioned by Mr. Calkins. We're just going to get another scheduling order.
Thank you, Your Honor. I have just a technical request and a suggestion.
Yes.
We have, based on the court's ruling on the order that you've just entered today already, there were a series of emails that are supplemental records. The court's ruling today adds to that with a set of emails. My suggestion would be that I'm fine with putting together and sharing it in advance with Mr. Worthington a certification of the supplemental record, identifying the record with an index, identifying the records in sequential page numbers, putting as a footer SR and then the number, if that's acceptable to the court.
It's acceptable to the court.
Your Honor, I object to the ruling because I believe that there's been an irregularity in the court proceedings. I believe that on the 15th, Mr. Calkins laid all this out to you, and rather than tell Mr. Calkins that he was free to file whatever motion that he wanted to file, you basically laid it all out at that time. This motion was pre-decided to such a degree
I'm
that
going to cut you off there, Mr. Worthington.
he wrote a 2-page motion with no quotes to the statutes at all, and he didn't reply to my response brief.
Thank you. Next case.
Your Honor, just as the court, I would like to have this supplemented record properly before the court. Is that acceptable, what I've suggested?
It is acceptable to the court.
Thank you, Your Honor.